watching this schooner.
We don't know that anybody who logs into the website.
Yeah.
So you got your own website?
Well, you can sit wherever you want.
CUCoffeeparty.com.
Okay, all right.
Anybody else
Do
want
you have
to?
any?
That's my shirt. My jacket. You can sit there.
Hello.
I gotta sit my computers in.
Christy, I'm Mark Ansel, how are you?
Nice to meet you.
Shane.
Shane, nice to meet you.
Yeah, do you know, Billy, typically, how many people tune in to watch the live streaming, or do we have those figures?
Steve. It's usually about a handful of people, but it depends on how popular it is or how well we
There is
A
tea
half
if you
dozen.
don't drink coffee, by the way.
About 10 people tried to get in from out of state for our open mic night, but the broadband was like horrible over our last location, so they just kind of got a stuttering view of some of the
Yeah.
musicians playing.
Yeah.
So if a lot of people know about it, they'll watch, and I'm recording it too.
So when you record it, it's archived and people can go back and watch it.
Yeah, I'll send it up to YouTube.
Yeah, the free speech open mic has been on YouTube since the end of January, and I think we've had like about 300 people watch it so far. So.
Well, thank you for catering if this is from you.
This is Dell.
Yeah.
All this is Dell, I'm sure.
She's pretty thorough.
She's pretty thorough. Yeah,
I'm gonna dig in.
she's an organizer. I've been teasing her now, she's a community organizer.
We need more community organizers. Yeah, she's been a lot of help to me the last few weeks because, you know, I mean, I don't know how much you know about Coffee Party USA, but
I don't know anything.
well, we don't have a lot of money. You know, I mean, everything that, I mean, it's a national movement.
Okay.
We started on Facebook.
Okay,
We've got about 350,000 fans on the Facebook page, but we've also got about 120 local chapters.
okay.
We've got, aside from the one in Champaign, we have one up in Chicago, we have one in Rockford, we have one down by St. Louis, we have one in Naperville. That's just Illinois. We've got about 15 in California. I mean, we're just spread out all throughout the country. And,
How long ago was it organized, or how did it start?
it started on Facebook.
Wow.
Yeah, our founder, Annabelle Park, she just made I mean, she's an activist from the get-go. She just made a video on Facebook, just kind of expressing her kind of, you know, frustration with some of the Tea Party activities. And, I mean, it went viral. I mean, we had our 1-year anniversary, January 27th.
Okay, so that gives me an idea of how long the bigger formalization
Yeah.
started early 2010 then.
Yeah.
Kind of think of it that way.
Yeah.
Okay,
Yeah.
terrific.
And we just went through a membership drive in February, and we was actually able to raise over $120,000. Yeah, all from, you know, just like single citizen donations. You know, I mean, there's no corporate money. I mean, nothing like that. I mean, it's the epiphany of grassroots.
Cool.
And I'm on a national team. We're going to formalize an official board of directors in June. I'll probably be on that.
Well, that'll be a national board of directors.
Yeah.
Okay,
Yeah. So we're just we're really working at it.
terrific. 350,000 you said on Facebook?
Yeah. Yeah. You know, we've got a YouTube official, official page, coffeepartyusa.com. Had a national convention in September of last year in Louisville, Kentucky. Yeah, I mean, we've done a lot of stuff with very little money.
Great.
It's great. I'm very happy to be a part of it. So.
Kim is on her way in,
Okay.
but we could go ahead and start.
Okay, awesome. Thanks everyone for joining us. I'd like to welcome Mark Ansel, who's going to be our speaker today. For those of you that have been keeping up on the Facebook, Citizens United and Young Politics is one of the issues that we've been dealing with a lot on the local and national level, specifically the Citizens United ruling. So I figured, be a good opportunity for us to maybe learn a little bit more about this ruling. And Mr. Ansel is very familiar with it, so he agreed to come in and speak to us. So thank you.
Oh, my
Thank you.
My pleasure.
Figured we could just start by going around, introducing ourselves. Sure. Just
We're meeting back up here at 8.
Peter, would you like to start?
I'm Peter Michaelov. I've been involved with the Champaign-Urbana Coffee Party since about the second meeting, which was last spring sometime. And I feel it's really important for individuals to get out there and make their voices heard. And, you know, especially with something like Citizens United, the presence of big money makes it difficult for individual citizens to have input and influence. And I think that's the kind of thing this group can accomplish.
Hi, I'm Christine Mullendorf. I started attending the meetings at about the same time, and I was really inspired to begin making a difference in politics and begin having my voice heard, and was unhappy with the general political climate at that time, and would love to bring a voice back to citizens, because especially with money in politics, I feel like we've lost a lot of our voice.
My name's Shane. I guess somewhat new to the group. I've attended a few of the meetings. Kind of just the whole realm of politics in general is, a new thing to me. So I'm kind of, seeing what's going on, what are some of the, I guess, initiatives out there that, what are we trying to do, so I just kind of see where we're going with that.
Hi, I'm Steve Lund. I've been involved since the second meeting this group's ever had, which was back in the beginning of last March. Lately I've been focusing more on the technical side, showing people over the internet, hey, we're not scary people, we're just like you and your neighbor. I got involved in this because of arguments with my cousins who are Tea Party members in Danville. One of them actually leads the group over there. And now you're next.
My name's Billy Sears. I started around the same time Steve did. When our original organizers kind of dropped off the face of the earth, I more or less, inherited the responsibilities. I didn't really have too much background experience in terms of politics. I just kind of had this sense of frustration in that, my voice wasn't being heard like a lot of other people. I just heard some of the rhetoric from the Tea Party, which I do agree with some of it. I mean, we do have a pretty dire financial status in our country right now, but I didn't really feel like they had all the answers. So we found out about, the Coffee Party, researched it, agreed with what they were going with, started attending. In the last year, well, it's been almost a year for me, kind of worked my way up the ranks, National Support Director, in charge of support for the Midwest. Probably going to be on our permanent board of directors, so that's really going to help this local group out in a lot of ways in terms of, getting money for one. But that's me. So, okay.
Hi, I'm Kim Hanley. This is my second in-person meeting for the Coffee Party. I've been politically active off and on through my life. My parents were very active Republicans, and my mom had run for city council in Lubbock, Missouri, years ago. So it was sort of always discussed in my house being politically active, although I was not a Republican from a very young age. I've been active off and on with politics until I guess about. It's been, I drove in from Mattoon and I'm getting overheated all of a sudden too. I became very frustrated during the Bush senior years, and I kind of stopped some of my involvement because it kind of felt like, what was the point? It seemed like nothing was, no voice was. If you didn't have money, you couldn't get heard. And so I just kind of threw myself into work, and I think what a lot of people at the time that I was involved with, it was basically things were too complicated, or also our jobs take up too many hours, who has the time? We're very frustrated, but the system is too big, and who has the time? So we just sort of shut up and concentrated on what we could, maybe with ourselves or with our family. So I'm glad to be involved again. I've been contributing some notes, some writings, which I like, enjoy writing, so that's kind of what my contribution has been to this group. You might have seen some of my stuff online, but anyway.
Well, Ken, I know you, but I'd still like to hear how you would introduce yourself after these introductions that happened already.
Oh, well, I do it like this. I'm Ken Beck. I'm Dell Williams' husband. I'm not really a joiner. I'm sort of here because I'm interested in this particular topic, which the folk wisdom about the Citizens United decision sort of underlines, in my mind, the fact of the matter, which is governments are expensive. They use a lot of money. They need a lot of money. So the people that have the money are basically funding the government, and they, by virtue of the fact that they funnel the money into the government, expect the government to do their bidding. I think that's been a fact about governments from the earliest recorded mention we got. But in this country, we have a sort of a folk notion of democracy, which is somewhat mythological at this point, since the money has been gradually funneling up. I mean, the level, the bar has been raised very high. So I think the Citizens United decision, at least as I understand it, and that's why I'm here, I want to find out exactly what's in it, or what it means. But it seems to mean that it's the beginning of the codification of that system in this society. So, that's what I would say.
Dell, I know you, but I'd still like to hear how you're going to introduce yourself and
Oh, okay, well,
what you would say about your being here.
I'm Dell Williams. Ken and I were both in the original coffee party meeting down at Kopi's over a year ago, and then we kind of dropped off the face of the earth for a while, and then finally came back. I got involved in it because I suppose I was kind of curious about its reaction to the Tea Party, and I guess at this point I don't think we're so much a reaction to the Tea Party as just trying to take a different approach to the conversation. Keep it civil, keep it rational. Although I like violence sometimes. I really enjoyed this week in Madison. At any rate,
And that was civil.
it was fairly civil, but it was in their face too. At any rate, I'm interested in this particular topic, and as I said to the group when we decided to look for an attorney who could help us understand them, that I understood the position of the coffee party on Citizens United, but I thought, I've never read it. I don't even know where the case was originally filed. I don't even know what the Supreme Court heard and how they based their decision. At the time, I didn't even know what the vote actually was, which was very close. And I'm sure he's going to tell us all this stuff. So, and I also, at some level, have my doubts about whether it even matters. But that's beside the point for today's conversation. So I happened to ask my boss if he could help me find an attorney who could explain it, and he was like, what am I, chop meat? Mark has actually been in front of the Supreme Court, and could probably tell us some interesting things about that experience. But he is, if I could do an introduction, he is a civil litigator. He's practiced law in Champaign in Illinois for over 30 years. His law practice is basically focused on business, construction, you know, you can tell most
Okay,
about
that's
why
fine,
you do.
that's fine.
But
Yeah.
for those of you who don't know what that means, and I know Steve Lund's mother was a paralegal, that's why you knew what my job was.
Yes,
She
she used to be.
used to be. We don't practice criminal law, or he doesn't, financial law, or I'm sorry, family law, that sort of thing. At any rate, with that, I'm gonna pass it to you.
Okay, and if it's all right, then what I'll do is I'm gonna introduce myself too, and then I'll
Sure.
start going right into the topic that we got today. Okay, so I'm Mark Ansel, I'm a local attorney here in Champaign, and I have been practicing here for 35 years. I have my undergraduate degree, Bachelor of Science in Psychology here at Illinois, and my law degree, 1974, here at Illinois, and I've been practicing here ever since. My practice is now limited to litigation, which means actually not just lawsuits, but anything that could wind up in a lawsuit. Really, more accurately, I am a dispute resolver. And if people see they're on their way into a dispute or already in a dispute, and they come see me, I'll try and help them get it resolved one way or another. If a lawsuit is necessary or the best path, that's what we would do, but we would always look at other paths first. Arbitration, mediation, negotiation, etc. I have always had an interest in politics, and I've always had an interest in constitutional law. And as a result, I have followed, all of these issues in politics and constitutional law, and the American government system have been a huge part of my interest. I did argue in front of the Supreme Court, one of two attorneys here in Champaign-Urbana to have had the honor to do so. And Bell asked me to talk about Citizens United. So in thinking about talking about it, I'm going to do this with my speech. I'm going to present it to you in 3 parts. First of all, I'm going to give you a brief history of campaign finance law in this country and how it came to be up to Citizens United and of course that latest chapter. I'm going to then talk to you about the Citizens United decision, literally the legal concepts and the reasons and the rationale, and it's going to be perhaps dry legalities for you for a little while, but I think it's very important for you to know and understand some of the legal principles that the justices had to apply in their different analyses about the case. I'll talk to you about the opinion and the legal principles that were dealt with in the case, and I'm also then going to talk to you a little bit about the effect of the decision, which was in January 2010, and of course, with the passage of the past year plus and the election that took place later in 2010, there's data about how much money came into those elections, from who, or maybe sometimes we don't know from who. And what appears to be the effect of Citizens United, at least in the last election cycle. And I'll close, I'm going to talk to you about the history, I'll talk to you about Citizens United and its effect, and I'm going to close with a section that I'm going to call, one man's opinion, that's me, or one person opinion. I'm going to give you some of my opinions on different aspects of this, the role of the Supreme Court and the First Amendment, and some other comments about how I see Citizens United in the context of this country's evolution and legal history. So, with that, let's talk a little bit about the history of campaign finance and corporate money in this country in elections. Actually, the history is about 100 years old. It first became an issue, corporate money became an issue right around the 1900s, as soon as the century turned. We okay? Okay.
Sorry.
By the end of the 1800s, corporations had become a very significant influence in the country in terms of size and power and money. Corporations are really not that old of an invention. They're only a few hundred years old. But by the end of the 19th century, railroads, life insurance companies, oil companies, and some others had become major influences in the country and in the economy, and not surprisingly, attempted to influence the elections. The election of Teddy Roosevelt in 1904 actually was the first one that made a big scandal out of corporate money in elections, because there was reportedly life insurance industry contributions to Teddy Roosevelt's campaign to help him win the presidency. And insurance money that was only an early time, but not the only time that they've talked about that influence. And Teddy Roosevelt, of course, won the election. However, as soon as he won the election, in his first State of the Union address, he gave a speech about the fact that we needed to control corporate influence over elections. And the first election and campaign regulatory law that was passed in this country was passed in 1907. It's called the Tillman Act. And it was a law that said that corporations may not contribute to election campaigns for federal office. Period. Plain and simple. At the time, there was a fine of $5,000 if you did contribute. In today's money, that would be an equivalent of a fine of over $100,000 for making a contribution. The idea, however, that you're going to follow now that's very important is that that law was plain and simple and said corporations cannot give money to candidates. What we're going to call direct contributions.
Now, you said this was at the federal level.
At the federal level, the federal government.
Corporations could give to candidates for state and local offices?
Unless the state barred it, because, you know, in our system, especially at that time, the federal government regulated its elections and set its standards, but it did not have any right at the time or control over state elections. The next major development was in the war years in 1943, and I'm talking about World War II here, when there was a lot of influence and power and impact on the government's war effort by the unions. Union influence was asserted by way of strikes, by way of money, by way of raising money. And at that point, the ban on corporate contributions to candidates at federal level was extended to unions as well. Coming through the war, that survived and persisted, and typically the bans and regulations that have been going on since then were bans on direct contributions by both corporations and unions. The next big push in campaign finance followed Watergate, which was in the early 70s, right after the election of 1972. And as a result of the Watergate scandal, Congress passed another law, that one called the Federal Election Campaign Act. And that was a much more complicated law and did more than say corporations and unions can't give money to candidates. That law included a few different provisions, including it set a $1,000 limit on campaign contributions per donor. It established a system of spending ceilings on candidates. Candidates couldn't spend any more than a certain amount of money. And it was the origin and development of a voluntary system of public financing for presidential candidates, where money began to be raised, in some cases voluntarily if you chose to contribute on your tax return. And presidential candidates could elect out of private fundraising, and if they did, would be awarded public funds. That was what the law was trying to do. That's what the law said. That 1972 law, of course, was challenged within years. It got to the Supreme Court, and in 1976, the Supreme Court issued a ruling. And the ruling, again, will get complicated, but they held most of the law valid and some of it not. The first thing they did is they said that it's unconstitutional to say how much a candidate can spend. The amount of spending ceiling was thrown out, saying that candidates cannot be stopped from spending any amount of money. Different issue than where they get it, where it comes from. They did uphold the provision of the law that says no more than $1,000 per donor. And they also upheld the option of electing out by presidential candidates of private money raising and giving them public money. And when they held all these things, one of the reasons that they gave, and it's very important now to understand the reason, because you'll hear what role it plays later, is that these are reasonable steps to stem corruption or the appearance of corruption in government. To quote, they said, to the extent that large contributions are given to secure a political quid pro quo deal, this for that, from current or potential office holders, the integrity of our system of representative democracy is undermined. Although the scope of these practices can never reliably be ascertained, the examples surfacing from the 1972 election demonstrate that the problem is not illusory, it is real. So this was the Supreme Court in 1976 talking about some examples that had come out in the 1972 campaign. Corruption, trade-off. Here's a big contribution, pass that law. 6 years later, in 1982, the court again faced another decision on this, and in that year, the case challenged this same law that we just talked about, the federal election campaign law, the provision that had established political action committees, PACs. Maybe I should have mentioned it a moment ago, but that law said that corporations, not only can they not contribute directly to a candidate, but any political contributions that are made by the corporation have to be made indirectly through a separate organization, a political action committee. It would be created by the corporation, but it would be the group that would collect or solicit money from the corporation's employees if they wanted to contribute. And only the PAC could contribute money for election campaigning in general. So this was challenged in 1982, that is challenging the requirement that corporations can finance campaigns only through PACs that solicit contributions from individuals in the company. By the way, hold on. Also, PACs in soliciting those contributions could only collect $1,000 a person, and the names of the people who donated had to be disclosed. This is important because this is the PAC concept accompanied a disclosure concept.
What year was the PAC concept established?
It was established in 1972 after Watergate in the Federal Election Campaign Act. And by the way, I may have misspoke or may have misled you. Corporation cannot make a direct contribution to a candidate, and it's been that way for 100 years in federal law. But PACs could make direct contributions because PACs would solicit from employees of the corporation who wanted to give. There were limits on how much they gave, and their names had to be disclosed. And that wasn't considered a direct corporate contribution because the PAC was not the corporation.
Now, was there any reasoning that by disclosing the names of donors to PACs, there was any sense of intimidation? If these are employees of the corporation, hey, you didn't give.
Sure. Well, I'll respond by telling you that this disclosure requirement and the possibilities of intimidation by having your name show up on the list, or intimidation by not having your name on the list, became immediate issues. And you're going to hear how they are dealt with now in the years between 1976 and here. I'll be talking about that a lot. Because I think that the concept of contribution and disclosure are the two fundamental foundations for what's going on and what the balance and the options are for campaign finance. Let me go on with that, okay? In 1990, the court again had another case come up and once again affirmed the restrictions on corporate spending in candidate elections This was in the Austin case, which is going to play a role later. In talking about the earlier decisions when it sent the Austin case out, the court said that there was a valid interest in the government ensuring that corporations do not spend their resources amassed in the economic marketplace to obtain an unfair advantage in the political marketplace. In 2003, the court finally upheld, in relying on Austin, the same very bans on corporate contributions to nonprofit corporate contributions, because the law had included and addressed corporations in general with no exceptions. Now, this brings us to the point of, no, I'm sorry, there's one other thing I'll have to point out to you. I had taken you up to 1990, and I want to point out to you that although the ban on independent corporate spending to influence elections was in place at that point for 30 or 40 years, it was interpreted only to prohibit ads on behalf of or advocating for a candidate. Might be called express advocacy campaign ads. I am an ad for Gore, an ad for Clinton, an ad for a particular candidate. Those kinds of ads were clearly within the law, but the law had gotten interpreted to say that those are the only kind of ads. Issue ads were not thought of as being a part of these restrictions. So corporations could go out and spend their own money directly on issue ads, like opposing health care or supporting health care. They weren't candidate ads. Both of the political parties realized when that distinction evolved that they could collect from corporations and spend a lot of money on issue ads. And the issue ads could affect elections. Because if candidate A supported health care and candidate B opposed health care, then an ad convincing the public to be opposed to health care would convince the public which candidate they need to vote for. This type of an ad was the beginning of the reference to the words soft money. Corporations couldn't give hard money directly for a candidate ad, but corporations were still free to give money that was being called soft money for issue ads. And in 1996, in the re-election campaign for Bill Clinton against Bob Dole, the Democratic Party accepted unlimited corporate contributions from corporations for the purpose of running soft money, issue-oriented ads. The Democratic Party. The candidate can't take the money for any reason from the corporation, but the Democratic Party took the money, distributed it to state parties across the country, and they all spent the money on issue ads, soft money. Television and radio ads were spent by both campaigns, but by far the Democratic money was way, way more. After that campaign, which helped Clinton get reelected, soft money in the 2000 election went through the roof for both parties. In the 2000 election, both parties broke every record in fundraising ever for soft money. The Republicans raised about $250 million in soft money, and the Democrats raised about $250 million in soft money. Both of them funneling the money to local parties for the purpose of targeting issue ads on issues that were really closely connected with the differences between the candidates running. Okay, so after that election in 2000, and we'll kind of skip over how our president was chosen here, but we'll just move on. Congress passed another campaign finance law because the amount of soft money that was being spent was so much higher than anything that had ever happened in any campaign in our history. That law technically is called the Bipartisan Campaign Reform Act, but it is what we know as the McCain-Feingold law. The McCain-Feingold law had two primary components, and boy, we're getting very close now to Citizens United. First of all, McCain-Feingold prohibited federal office holders or candidates from soliciting and spending soft money. Candidates couldn't ask for money to give to the party to run a soft ad. Secondly, campaign advertisements that were issue-oriented were subject to disclosure requirements on who was contributing the money. And the advertising we were talking about and that they passed in this law was broadcast advertising, TV and radio. The law actually had a provision that there can be no broadcast advertising within 30 days of an election or 60 days of a primary. These laws in the McCain-Feingold Act obviously got appealed up to the Illinois Supreme Court. And in 2003, in the McConnell case, the Supreme Court upheld the key provisions of the McCain-Feingold law. Now, I mentioned the McConnell case, and the last case I mentioned for you that was important in 1990, the Austin case, because a couple little things happened right after McConnell in 2003 that are going to bring us right to United Citizens, or Citizens United, okay? I would say that McConnell in 2003 upholding McCain-Feingold was the watershed of upholding campaign finance laws in this country. Because at that point in time, as you'll hear now next, things started to unravel. There was a 2007 Supreme Court decision that reversed a part of McConnell, the part of McConnell that prohibited corporate and union money to finance issue-oriented ads. At that point in 2007, the Supreme Court said, no, that's too much an intrusion on free speech. We want people to have issues argued fully and freely, and we don't want to allow any laws that are going to suppress ideas from certain sources. So soft money, issue ads, you cannot stop corporations or unions from making direct contributions. One of the things that McCain-Feingold set up to help implement and regulate was that it created the Federal Election Commission, the commission that was supposed to oversee and pass regulations to see that the McCain-Feingold law was respected. That commission, of course, had to make some interpretations now and then about the law, and then they heard the Supreme Court case that had come out saying that issue-oriented ads cannot be regulated. So the Federal Election Commission responded by saying that groups that were making issue-oriented communications did not have to disclose contributor identities if it was against the law to discourage or prohibit the speech of anybody, including a corporation, on issue ads, then the people who make the contributions need to be protected from identity to encourage the contributions. The only exception that the FEC made is if somebody gives money for that's earmarked for the purpose of an ad, as opposed to somebody who just gives money to a public citizen or common cause or an organization who happens to have political mission. They could give the money. But if they gave the money and said, I want you to use this money to advertise, their name had to be disclosed. Now how fine are we getting in the distinctions here? But it gets worse. Just before the 2010 election, now we're talking about a year and a half ago, The 3 Republicans on the Federal Election Commission issued a statement saying that the only people who have to be disclosed are people who give the money to the group and say, I want an ad opposing health care. Use this money to make an ad supporting railroads. And use it in Illinois. Now let me repeat what I said here in simpler terms. The 3 Republicans on the FEC said nobody has to disclose their names to give money to organizations who run issue ads, unless they say, I want it for this kind of ad to be run in this race,
In this location.
in this location. In other words, nobody has to disclose their name anymore. Because nobody is ever going to tell you exactly what ad and what race, knowing it had to be disclosed, when they can give you the ad and say, I want you to run ads opposing health care, but I'm not going to tell you where, and leave it to the organization to decide which are the key races. The effect of this by the Republicans, the 3 Republicans on the FEC, and by the way, there's 3 Republicans and 3 Democrats. The effect of this was that everybody felt pretty safe if they wanted to send their money to issue organizations for the purpose of advertising and not having to disclose their names. I would say that the effect of this was to just gut any disclosure requirements whatsoever in those types of situations. This is where the state of the law was when Citizens United got started. So now I'm going to talk to you about Citizens United and how it got started. Citizens United was a challenge to McCain-Feingold, and it was on behalf of a group who had put together a video about Hillary Clinton called Hillary the Movie. This group had planned to not put this video to CNN or let it be broadcast on TV or radio, but to sell it as a DVD, or give it away as a DVD, or show it in theaters, so that they wouldn't have to be subject to the disclosure requirements, because they weren't broadcast. However, then they decided that they would really like to show it on satellite, through satellite. But they got worried about whether they were violating the law if they did it that way. Is that broadcast? The definition in the law of broadcast did refer to television transmission. So it became a question, and they said, you know what, we need to file and ask a court if we're going to be legal or illegal in what we want to do here. We actually would like to run ads that tell people that you can go buy the DVD, not the DVD on TV. Could we do that? I think we need to ask a court that too. In other words, they identified and came up with a way that they said, well, it looks like this might not be violating the law, but we're not sure. And we don't want to go to jail, and we don't want to be fined, so we're going to ask the court. So they filed a complaint in New York in December of 2007, saying that McCain-Feingold applied to their plan with the Hillary DVD was unconstitutional. If it applied to them, it was unconstitutional. They ought to have the right to distribute a DVD. They ought to have a right to do what they're doing. And they wanted to make sure. That case got heard by the trial court, and the court said that they're not going to rule it unconstitutional to apply it to their situation. The case got immediately appealed to the U.S. Supreme Court, as can happen when you have a major issue. And it was being briefed at the U.S. Supreme Court in 2009 when something amazing happened. The Supreme Court had accepted briefs on whether or not their plan for Hillary the movie was afoul of McCain-Feingold. But the Supreme Court then issued a request to all the lawyers in the case and said, we would like you to argue and research the question of whether or not the ban on direct corporate and union spending is constitutional. In other words, they wanted to hear argument, not on just a little question here about whether that DVD and the way they distributed it was legal or not, but they wanted to know if direct contributions by corporations and unions, two candidates, could be lawfully banned under the Constitution, under the First Amendment. Well, this sent a signal, of course, that the court was looking at the big question. The court handed its ruling down on January 21st, 2010, and in that ruling, they voided all prohibitions on independent corporate spending in federal campaigns. In other words, they reversed 100 years of law. Now, I'm going to tell you now a little bit about the opinion and the reasoning in the opinion, and in this instance, I'm going to start talking to you about what the law is and what the law said and what the law had been saying about the First Amendment, free speech, corporate rights, and elections. But I think you got a flavor here for how things got, they were simple at the beginning, they got complicated at the end. But the ultimate concern and question that the court decided they needed to answer was, do these laws suppress or inhibit political speech? Or what some of us might ask is, are corporations speakers? Do they have a right to political speech? I'm going to walk you into the lawyer world and the decision in Citizens United. But before I do, I want to tell you that when Citizens United was handed out, it was a 5-4 decision. There were 5 different decisions handed out by 5 different justices writing on their own. This often happens in a case where the main decision was agreed to by 4 others, so that's a total of 5. But some of those said, I don't agree with that paragraph, but I do agree with this paragraph, and I do agree with this result. And the 4 dissenters, who didn't agree with the result, wrote their own opinions saying, well, I agree with that paragraph, but it gets wrong here in this paragraph, and therefore I can't agree with the result. If you wanted to read every decision that was handed down by every justice concurring and dissenting in the Citizens United case, you'd have to read about 160 pages. I'm going to walk you through the main decision. As presented by the Supreme Court, and did you say that this is something that you may have sent out?
I did send it out,
Okay.
yeah.
Dell said she may have sent it out, and some of you may have had it. This is what's known as a syllabus of the Supreme Court decision. This is a summary. If you look at it, you can see that it's a pretty long, complicated summary. But I'm going to walk you through it quickly and hopefully give you a bit of an understanding about legal principles involved. As explained in the summary, the legal reforms in the Act and the reforms in campaign finance that were passed in 2002 left a situation where federal law prohibited corporations and unions from using general treasury funds, their general money, their own money, to make independent expenditures for speech that is either advocating the election or defeat of a candidate or issue-oriented, what they call an electioneering communication. Prohibiting general corporate funds from being spent for those purposes. The definition of an electioneering communication was any broadcast, cable, etc. that refers to clearly identifiable candidates, things like that that you'd find in the law. They also noted that the law said that corporations and unions may establish political action committees for express advocacy or electioneering communications, as we talked about. And they noted that in the McConnell case in 2003, the court upheld a limit on electioneering communications. And in 1990, in the Austin case, the court said political speech may be banned based on a speaker's corporate identity. Now, let's be careful here. First of all, when they say political speech may be banned based on a speaker's corporate identity, what they're saying is that they said that corporations can be banned from political speech. Individuals can't. And what they're saying is corporations can be banned from spending their own money on political speech. Individuals can't. So they note that that is what the law was at the time. But then they held as follows. First of all, they found that the question of whether the Hillary the movie was going to be allowed or not could not be answered without leaving a lot of ambiguity and unknowns still out there. Without telling people in clear and certain terms, this is legal for you to do, this isn't. This ambiguity, they felt, the five, although most everybody agreed with this part, had a very important effect in their eyes, a chilling effect on speech. That is, they felt that there were some people who might want to say something and it might be legal, but they're not sure it's legal, so they're afraid to say it. This is, in my view, something that can really happen. And if you don't have the money to ask the court whether it's legal or not, you'll keep your mouth shut if you're afraid. It's always been a principle of the free speech and the First Amendment law that would say anything you're going to do to regulate speech or to prohibit it has to be very specific and very clear, because we don't want any spillover effect. We start with the premise that free speech is important. So you better be very specific and clear. And in their eyes, this situation, even if, to talk about whether Hillary could or couldn't, wouldn't make it clear. So they said, we're not going to talk about something that's going to leave it confusing and ambiguous out there. We have to clarify this. And in order to clarify this, we have to consider whether or not all of the precedents make sense and are legal. Now that was their excuse for going back and saying, we're reconsidering some things that were decided in the past. Logic can't argue, in my view, with the fact that it was a mess. And there were people who might have been afraid to talk, even though they really had a right to talk. Is it possible or plausible to come up with a law that's going to be so clear in every situation that everyone's going to know? In my view, probably not. So if you're going to use that as the reason why you're going to throw a law out, is it possible for Congress to ever pass a law that's going to be upheld? Probably not. All right. As the court said in its terms with this idea of not wanting to chill lawful speech, these restrictions actually act as the functional equivalent of a prior restraint. That is, they're the same thing as if you were going to tell a person, you can't talk, you can't say that. Logically, I can understand that in a vacuum. Well, you know where it went, and it's simple to say where it went, because what they said was the Austin case was overruled. The Austin case is the case that held that you can stop corporations from political speech, but you can't stop individuals. They saw no logic in that in light of the way it was working, and I should say in light of they felt it wasn't working. And given that, the part of the McConnell case that put restrictions on independent corporate expenditures and made them go through PACs was also overruled, because it didn't make sense to them without chilling speech. I want to expand on this a moment because I think this is the heart of the matter. The prohibition, this is what the court says. The First Amendment says Congress shall make no law abridging freedom of speech. No law. The statute that prohibited corporate independent expenditures for political message, they viewed as an outright ban on speech. corporations were not allowed to talk. Let's reserve for a moment whether corporations ought to have the protection. That's what they concluded. It's a ban on speech, notwithstanding the fact that a political action committee created by the corporation can still speak. For a political action committee is a separate association from the corporation. Well, if they're a separate association, it doesn't change the fact that what this law says is you can't talk. They can talk for you, but you can't talk. They say this, because speech is an essential mechanism in democracy, and that's what the First Amendment's supposed to say. Political speech must prevail against laws that would suppress it by design or even accidentally. We cannot allow suppression of speech. It's always been the law that any laws that burden speech are subject to very strict scrutiny, and they have to be very narrowly tailored, etc. They said this. Okay. The First Amendment stands against attempts to disfavor certain subjects in favor of others, to disfavor certain viewpoints in favor of others. That all makes sense. But also, it has always stood against disfavoring or distinguishing among speakers. You can talk, you cannot talk. They say that the First Amendment doesn't allow any of that. The government's not allowed to choose who they prefer to speak and who they prefer not to speak. Now, the court recognized that the First Amendment applied to corporations and extended this protection to the context of political speech for corporations way back in the 70s. They did hold that. Okay? However, the court upheld limits on direct contributions to candidates because they recognized an interest in preventing quid pro quo corruption, right? Remember we said that? Here's what the court says now. Noting that they had also invalidated the expenditure ban about how much candidates can spend, they said from the beginning, you can't tell them how much they can spend. They decided that it was inconsistent to say that the government cannot suppress speech and still tell certain speakers that they weren't allowed to speak. Inconsistent. They looked at the reason that Austin, the corporate ban case, said that they didn't want to allow corporations to speak. And at that point, back in 1990, the rationale was this. Not only did the government have an interest in avoiding the look of corruption, I'm going to quote here, the government in 1990 said by the Supreme Court that they had an interest in preventing the corrosive and distorting effect of immense aggregate of corporate wealth. Corrosive and distorting effect of immense corporate wealth that has little or no correlation to the public support for the corporation's political ideas. So what the court had said back in 1990 was, it can distort speech because they have so much money that they are distorting speech with no indication that the public overall supports that. Well, the court found this, again, conflicting. There was a line of cases forbidding speech restrictions based on identity, and there was a line of cases permitting speech restrictions based on identity. Now, once they set up this conflict, which I must say, in the abstract, it's real. And the reason I say that is because we have here a situation of conflicting rights, conflicting interests. I want to give you a concept here of conflicting rights. Are the Nazis allowed to march in Skokie? Well, I guess free speech says that the Nazis are allowed to march in Skokie. But I guess that the woman who's a Holocaust survivor standing in the window and sees those Nazis and has a heart attack and dies has a right too, doesn't she? or the people who have more emotional or mental breakdowns because of what they've seen. These are conflicting rights, and these are not easy to resolve. In this case, there are conflicting rights. The question still remains, what's the right decision? This court said the First Amendment protections do not depend on a speaker's identity. Moreover, they should not depend on the speaker's financial ability to engage in public discussion. How can you stop and say, rich, you can't talk. Poor, you can talk. Any more than you could say, poor, you can't talk. Rich, you can talk. As a concept, this is what the court is lining up for their decision. Distinguishing then, how about wealthy individuals? Wealthy individuals are not being restricted, they can spend as much money as they want. So, you're not going to restrict wealthy individuals, but you're going to restrict wealthy corporations? That's not logical in their mind either. Then they go on and say, not only that, but this statute that said corporations made an exception for media corporations. In other words, TV and radio weren't prohibited from advertising and speaking on political issues or on behalf of candidates. Now we know, and in fact, it's rare, but most of the time they don't. Most of the time the media companies are just passing on the news or somebody else's ad. But if they wanted to start advertising for candidates under this law, they wouldn't be stopped. Only the non-media corporations would be stopped. Now the court is setting up every possible illogical distinction that exists in the law. The differential treatment of media corporations and other corporations can't be squared with the First Amendment. Nor can we square it with distinguishing between for-profit and not-for-profit corporations. But how about this? Small corporations aren't allowed to give contributions. Little corporations are not allowed to give contributions under this rule. So the Supreme Court says, what sense is that? If you're worried about great accumulations of wealth, you've even swept small corporations up into your bar. All of this attempt, and you could say, all of this setup that Congress was trying to do and say is nuts in the eyes of the Supreme Court. It doesn't work. It's overly broad, it's underly broad. It includes people who shouldn't be barred from speaking, it excludes people who should be allowed to speak, and the First Amendment is too important, as they say, to allow this. Okay, the court now concludes that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption.
Say what?
Say what? Here's where I think the court steps off of the cliff. Because now, to justify what they're about to do, they say, independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruptions. That speakers may have influence over or access to elected officials doesn't mean that those officials are corrupt. And the appearance of influence or access will not cause the electorate to lose faith in our democracy. Say what? Now I think we have some old men, and maybe women, we haven't heard the lineup yet, in black robes who live in seclusion from the outside world.
Virginia.
Okay? They go on. The government's asserted interest in protecting shareholders from being compelled to give money would allow the government to ban political speech even on media corporations who have shareholders. Therefore, it's under-inclusive. It must include media corporations if it's not to make an irrational distinction. But however, it only protects a dissenting shareholder's interest in certain media for 30 or 60 days before an election. That doesn't make sense to us either. It's over-inclusive. I'm not going to go on anymore. The Supreme Court the majority has chosen to say that there's too much irrational, inconsistent, or ambiguous in the scheme that evolved over the past 100 years. The court therefore returns to the principle that government may not suppress political speech based on the speaker's corporate identity. No sufficient governmental interest justifies limits on political speech of nonprofit or profitable corporations. That is the end of part one of a two-part decision. It's interesting, and I'm going to give you my opinions on it in a moment, but it's very important that you hear part two. The court, however, finds that sections 201 and 311 are valid as applied to the ads for the Hillary movie and the movie itself. Well, what are those, 201 and 311, that the court said are valid? Disclosure requirements. The court has held and does hold that disclosure requirements may burden the ability of some to speak, but they don't put a ceiling on campaign-related activities, and disclosure can be justified by a governmental interest in providing the electorate with more information about election-related spending sources. Sounds great, okay? You can make people disclose. You can make corporations disclose. You can make them disclose where it comes from. In principle, this is what the Supreme Court is saying. The idea here is to be ensured that voters are fully informed about who is speaking. Disclosure is the less restrictive alternative to more comprehensive speech regulation. What the court is saying is, instead of saying you can't speak, you can't say that, you can't say that, just have disclosure, as long as the people know who's talking. To your question, the court noted that Citizens United didn't want to disclose who their donors were. The court said, no. If the law says you have to disclose who they are, that's okay. You have shown us no evidence that your members face threats, harassment, or reprisals if they are disclosed. In other words, the court said that in the case of requiring disclosures, we're not going to accept somebody saying, I'm afraid. You're going to have to show us some reasons and evidence that there's a real impact on it. Now, that is the decision of the majority, and I'm going to talk to you for just one moment more about the decision's effect in the past 14 months. In the 2010 election cycle that occurred in the past 14 months after this decision, outside group spending on issue ads and candidate ads increased 400%. 400%. Jumped to $300 million in 2010. In 2006 it was $68 million. Okay. Nearly half the money was spent by 10 groups. 10 groups spent nearly half of that money. Those 10 groups, the largest group, $31 million, was the U.S. Chamber of Commerce. There's another problem that happened in the election cycle. Contrary to the Supreme Court's promise that voters would be able to give proper weight to the speakers if they knew who they were, because of the nature of the spending, because of the section of the law that they were trying to apply in Hillary, which was different than the sections of the law that they were applying in political action committees, and for direct corporate contributions, there were no laws because they had just made it legal again for the first time in 100 years. Most of the sources of the money in the 2010 off-year election were unknown and not disclosed. The justices who may have thought that there was disclosure, or who might wanted to tell Congress, you can pass disclosure laws. More than half of the money in the 2010 election, the sources were unknown and undisclosed. The U.S. Chamber of Commerce didn't disclose the sources of the money that they got. Okay? of the 75 contested elections that changed hands in the House, 60 of them received the vast majority of the money. Did they have an impact? Huge. Now, I'm not saying to you that the amount of money that would have been spent would have been higher than in the previous election, even without this decision, because we all know that every election, the money spent is more and more and more and more and more. But in looking at it and in seeing the number of groups that contributed half of the increase, in looking at the elections that they focused and targeted, and in looking at the results of those elections, in my view, empirically, there's little doubt about the effect here.
Now, who were the other 9 groups?
The other 9 groups of the biggest 10 were, in order, U.S. Chamber of Commerce, 31 million, American Crossroads, Carl Rove's
Yeah.
group, 21 million, American Action Network, we don't know, they didn't disclose. I mean, some people may know and you can find this out. Crossroads Grassroots Policy Strategies, another Carl Rove group, American Future Fund, Americans for Job Security, American Federation of State, County, and Municipal Employees, National Rifle Association, 60 Plus Association.
A lot of conservative groups there.
The only ones who disclosed were Carl Rove's American Crossroads, the National Rifle Association, and a group called SEIU COPE, and I don't know who they are because I haven't looked them up myself. So,
It's union.
Yeah.
okay,
Service
okay.
employees.
They disclosed.
No, they disclosed.
Everybody else didn't disclose. All right. All right, now I'm going to get to my last part of my talk here and share with you what I'm calling my own personal opinions, okay? The First Amendment, free speech, when it was passed, I don't know if the corporate entity existed as an entity under the law, but if they did, it was brand new. I don't think that the founders in 1789 could have envisioned television or radio or the amount of money that it would cost to buy ads or the impact that the ads could have on swaying public opinion. Psychologists will tell you that sometimes a headline in the paper on a Monday on a particular issue can sway public opinion 10% within 3 days. The headline might be true, it might be false, but it sways public opinion. But the First Amendment was an idea that was a good idea at the time. Free speech, marketplace of ideas. We do not want to exclude any idea. We want every idea, because the more ideas, the more we as a people are going to be able to think, hear, learn, and decide. Well, that's an issue, but the concept of, we don't want to exclude any ideas from the marketplace of ideas. We need to hear all these ideas. We certainly don't want government telling us which ideas are not allowed.
Right.
And that's the idea that was the First Amendment. Okay? And of course, whose job is it to interpret and apply the First Amendment? The Supreme Court's. When the Supreme Court says that a law is unconstitutional because of the First Amendment, Congress cannot pass another law unless it's a whole different approach. What approach is left here? Because in my view, there is a disclosure approach left. And you know what? There was an attempt in this Congress to pass a disclosure law, to make the disclosures required everywhere across the board. It failed in filibuster in the Senate by 1 vote. The filibuster was a Republican filibuster. Okay? So there's still an effort, and the law still comes up again, but it hasn't got passed. Maybe that would make a difference if we knew who, and every time the ad was put on, this ad sponsored by GM, or this ad these ads sponsored by so-and-so, maybe. The idea there is, according to the Supreme Court, who thought it was that way already, but they were wrong. If we know who's sponsoring, we can decide for ourselves. Oh, of course, of course they're, okay. Is that enough? Or if all you got day after day was business point of view, you would lose your objectivity. You decide. It leaves a big responsibility on us as citizens. A lot of people wonder if this court has now become just a political machine. Okay? This has been wondered for a long time. Okay? Some people say, well, the court's always been a political machine. We just realized it and we're not naive anymore. Some people say, no, the court's not a political machine. They were trying to apply as best they could. Well, in my view, whether those 5 justices really believed what they were writing and believed the outcome and believed it was the right thing, or whether they were all Republicans, I'll never know. I do know that our country has reached the point where this court's decisions are predictable by political party. So did they come in with a bias? Of course they did. We all do. And they were politicians before they got on the court. So are they seeing things through their bias and believing what they see? Or do they know better? Do they know that they just handed their party the golden egg? I can tell you that it's a bad thing that's happened, that the court has become politicized. Because the court was the only branch of our government that was supposed to be free of and above that. And we've lost faith in our Congress. And we all question our president from time to time. And now we have no faith in the court. So of course, we have no faith. It's a bad thing. Now let me talk about something else. I said that they couldn't have envisioned TV back in 1789. One of the things this court said is, you can allow satellite and bar television broadcast, but then the internet comes along. So you really can't control technology. Every time you've tried to control technology, Congress, in these campaign finances, they find a way around it. It doesn't work. It's not workable. There's a point to be made there. Hard money, they found soft money. Broadcast transmission, they found satellite. Internet. Okay? We can talk about whether technology in some ways has helped us and whether we're using technology for what we're trying to do, what you're trying to do here. And I think it has helped us, and I think it has hurt us, like everything else. The car was a wonderful invention. It helped us a lot, but it also hurts us a lot. I personally am intrigued by this concept of prohibiting certain speakers or certain topics or certain issues or certain thises or that's versus not prohibiting anything, but making disclosure necessary. I don't really know how much good that will do if the American people are lazy, if the American people won't pay attention, if the American people don't have the proper skeptical approach to everything that they hear. And I also don't know that even if they did, if they got a steady stream of one point of view, how could that not affect their understanding of the world? I struggle with that. But my biggest struggle and my biggest problem with this decision is this. There are only 24 hours in a day for the broadcast media to broadcast. There are only so many ads that they can put out in a day. There are only so many. And the conduit of advertising on TV and radio is limited. And if we give the airwaves in those situations to the highest bidder, we will only hear the point of view of the wealthy. That is a logic that I, so far, have held for months. Can't figure out a way to get around it myself. If you have if you have 6 lanes, and all lanes are being taken up by Cadillacs, you're not going to see any Fords. Well, if you have a limited conduit for transmitting, and it goes to the highest bidder, you're only gonna hear what the highest bidder has to say. That's a concern of mine. Now, you do have that old corporations and unions. You could say that, no, but maybe the unions will counteract the corporations. You could say that maybe you are still getting 2 points of view, although 2 points of view ain't enough for me. So this is where I am struggling in my thinking about it. But the effects of this decision and the inability of Congress to respond in any way to try something, anything, do something, that's a tragedy in my view.
I would say, just from my personal point of view, that, the internet, that is really, it's given us the opportunity to, really look at the different point of views other than what, like the mainstream media presents us, what some of the more, maybe wealthy, investors want to present us. The internet is really, that's our tool. That's how we can, on an independent level, kind of research where this money comes from, the impact it has, and things like that. So, I thank God for the internet.
I thank God for the internet too, because the internet is a means to reach each other and find each other and disseminate a point of view that doesn't require $150,000 a minute.
Also, the architecture of it is very awkward for governments to control. It's node to node. Yet you see in this uprising in the Arab countries now, governments try to shut down the internet, but you can ping around those problems.
The original invention of the internet for the military's use in this country was premised on that idea.
Right.
That if we could have enough nodes going, they couldn't take all of them out at the same time,
Right.
and we could continue to be able to be in touch.
Works beautifully.
So far.
Yeah. Well, it's very difficult to make it, to break it.
Right.
Very difficult.
Right.
I'm interested in your idea about the mindset of the founders, because this idea that the court has of going back to the Constitution and deeming this, that, or the other thing unconstitutional makes you really focus. And I know that Glenn Beck is always waving his, Boehner, they're waving their little copies of this 18th century document around.
Yeah.
And the idea that speech shall not be infringed. I wonder if, the founders were wealthy, and the founders had technology. They had a technology that had been around for a while at that time, but they had certainly had the printing press, which was their way of disseminating information and influencing opinions, and they would have considered that speech, even though it was writing. So in that, you sort of can see that there's a validity to the logic of it. You can't start saying, just because we have this fabulous, rapid technology, it doesn't mean that they didn't have a technology that disseminated information. So that idea is in there, in their minds.
Right.
And as far as that goes, John Hancock was very wealthy, and wealthy to the point where he was almost a corporation in his way of doing business, the way he thought about what a government should be. So that's built in there too. But the idea of giving money and equating that with speech, I find that problematic. When you first started talking about this in terms of freedom of speech, I was thinking, now how is a corporate entity or a union entity or any organization as an entity a speaker, in the sense that, because a corporation, it's like saying that a mass of people have one voice. That might be true, but there's something funny about that.
Well, one of the important points you make that I think most of us would agree with is you don't want laws, to use your terminology, that favor or disfavor certain speakers. I think we would all agree with that. But can you argue there's a difference between favoring or disfavoring speakers based on who you are versus favoring or disfavoring speakers based on what you are?
Well, I'll just comment briefly on both, on what both of you just said. First of all, Ken said something very important that I probably should have said, I left unsaid, but I'm glad that you reminded me of it. You know, back in the founders' days, the printing press, that wasn't verbal speech, but it was considered speech. So what's the definition of speech as the word is used in the First Amendment? It's a very good point, and I'll try and answer it to this extent. The general consensus that developed in the first 100 or 150 years of the country was communication of ideas. Communication of any kind, verbal, written, nonverbal, you know, that's speech. They held that that was speech. Okay, so any communication of an idea, okay? Now, if you start, if that's your concept of speech, and that I must agree with in concept, I understand the concept, it doesn't talk about who yet. If that is the concept, then it wasn't a big leap to say, and we want to encourage ideas. So let's say you have a robot, okay? And the robot's doing processing and is all about to come up with something, and like say, this is the best move on this chessboard right now, or something else. They may not have any rights, but the court would say, we ought to just let them. Who knows what they'll say? They're going to say something that's going to light a light bulb in our minds. So we want every conceivable source and means of ideas to be presented. This is the theory of the marketplace of ideas. Okay, so it doesn't matter whether it's verbal or written or nonverbal or anything. Okay, and as far as who, part of that logic could be whatever percolates up to the corporate board of directors, however, whyever, whether it's selfish, whether it's reflective of the shareholders, whether it's not reflective, whatever it is, put it in the pot. That's the philosophy. Okay. The real question I think you asked is, corporations aren't people. Should non-people have rights at all? It's a very tough question, and I didn't study the origins of the holding that corporations have rights, including First Amendment rights, although the court has never said that they have a right to do anything and everything that people do. They just keep saying, well, that's something that we're going to let them do. Well, that's something we're going to let them do. Well, that's something, maybe something will come up we won't let them do, but that's something we're going to let them do. And it was easy to couple the First Amendment with corporate rights, because the marketplace of ideas concept was, oh, great, just more ideas. We love more ideas. You know, if the founders knew then what we know now about corporate power and the conglomeration of corporate power and wealth, and if they knew then what we know now about the means of communication and the limits of the pipeline for buying and conveying ideas, I suppose I should say, and the fact that the government is swayed like sheep when a new headline comes out, they swing 10% of their opinions. I mean, if they knew all that, what would they have said or done? That's the, unanswerable question. I know when you balance these things, I do know and believe that these justices could take rights from this side and rights from this side, and they get to choose. We don't get to choose. They get to choose which of those rights they want to prevail. Whether they're operating in good faith or in bad faith, I don't know. But I recognize how, at this point in time, we are so far away in terms of the changes that have occurred in our society from the founders. You know, the idea that the founders and what they would have wanted, what they intended back then, original intent idea, that as if that's the only thing that should control, is an idea that I reject. And I might say it's also an idea that the people who preach it reject, because they find it very convenient whenever they want to say something for a different reason to say it the other way. You know, perhaps the most important thing to me in this is one sure way that you, and I'll say we, the people, could change the situation is to amend the Constitution. Why don't we do that Sunday or Monday? Let's get it done, Sunday or Monday. Can we get it done by Sunday or Monday? No, of course, the reality of the situation here is in amending the Constitution, the original founders thought, you don't like it? Amend the Constitution. The reality is it's become almost impossible until things get so bad in some way that that the people get up in arms and the politicians have no choice. The system has become, the system in my view has slowed down to almost a crawl or no momentum at all anymore. It's not capable of addressing the changes and the things that are happening to us anymore.
I think that my original idea about this was probably not quite right. Actually, the way the law is presented, it is folk wisdom, because you make a very good case. I mean, when you present the synopsis, the syllabus, it seems like the court really did try to strip away 100 years of attempts to throttle the corporate right to speak.
So when they say, guys, it's not working, we're wiping it away, start all over.
But everybody now, on both sides, whatever your political opinion is, you have the right to raise as much money as you can from wherever you can get it and go to it. I mean, they're not saying, just at the moment, this moment, things are kind of lined up for the conservative mentality, but that could shift. I mean, I keep thinking that the more trouble the society gets into, the more unrest there's going to be bubbling up through the pipeline.
I think that's right.
And I think that you see that in Arabia now. You see this incredible uprising. People, it's very messy, and it's fraught with. And that true, the stuff that the Tea Party conjures up, some of their casual images and so forth, if you go back and look at the history of it, well, you have a bunch of white guys in Indian costumes throwing tea into the Boston Harbor. Why? Because they were not happy about tariffs. They were not happy about taxes. That's all well and good so far, but some people don't pay enough taxes.
Yeah.
So
what worries me, Ken, about it, because I think you're right. I think, if things get bad enough,
yeah,
maybe something will happen. But what worries me is, how bad do things have to get before something happens?
well, there's a lot of forces at play.
There's a lot of forces at play.
I mean, climate change, in my opinion, is a very serious problem. Not for the planet, because the planet's going to be fine, but for humans, because we are very fragile, and we depend for our survival on a certain, baseline normalcy in weather, and that's, even if they got serious in the Congress, across the globe, all governments in general, I think that we'd still be in for a very bumpy ride. That's just the science of it.
Okay, so what you're saying, and
What I'm saying is that as things go south with the climate, that's going to put a lot of pressure. People are going to be stressed.
Mhm.
And that's going to contribute to there's going to be a time when the stupidest monkey on the planet will realize, oops, they were right.
Right, but
The science was right.
Let's look at a couple of dynamics right now. I don't know if it's true or if it's permanent or if it's setting a long-term trend, but the confrontation in Wisconsin between the governor and the unions
Mm.
appears to have gotten a few more people involved and interested in realizing that you can't just justify anything on the basis of fiscal responsibility,
Mm.
and that you can't just target one group to bear the burden of it.
Right.
How much is that gonna change in the next 12 months, the attitude about business, the big business in the minds of the electorate, or the silent middle, or whoever? How much is this Wisconsin thing gonna start spreading and showing that we do need to, a little more balance here? I don't know the answer to it.
Yeah, it's really hard to say, because the blogosphere is already on it. You know, some people say, well, in 12 months they'll forget all about this, because it's really not, it's not critical to the largest number of people.
Yeah.
Well, let me ask this question of this group. This will give me some, I'd like to collect some data here for myself. First of all, how many of you were old enough to vote in the 2008 presidential election? All of you? Everybody was old enough to vote. Okay. How many of you voted in the 2008 election? All of you? Okay, I'm really happy to see that. I'm really happy to see that. Because voter turnout, of course,
It's horrible.
is an issue all in and of itself, that if we could ever get everybody out, what would the result be? I don't know, it might be worse, it might be better. The other thing is, when you talk about the climate, by way of example, you know, it may be that by the time things get bad enough for people to say you were right, it will be too late. Now, too late for what?
Yeah, too late for.
Too late to wipe out civilization, or set us back 200 or 300 years
For
of
having
living in
Kennedy in the
Thunderdome?
Assembly, it's kind of already too late.
Right.
If I could just touch on a few pieces of this dialogue over the last few minutes. You know, you were talking about the Boston Tea Party.
Mhm.
You know, I mean, I think we all know the story of that, but, you know, I mean, just from my own independent research, you know, something that I found, you know, a little piece of history that's been omitted in a lot of cases is, you know, not only were they dumped in tea because of these tariffs, but they were also dumped in tea because this was one of the first recorded examples of government and industry working hand in hand.
Yes.
You know, the East India
East
Tea
India Tea
Company
Yes,
had
yes.
established a monopoly. You know, the small independent business owners, you know, in the colonies, I mean, they weren't making ends meet, and, you know, they had had enough.
Yes,
Yeah.
but what happened was that the insurrection got out of hand. By the time there's bloodshed in Concord, at Lexington, you know, it was already a case where King George he backed off. They got what they wanted out of their protest, but they had stirred up to the public to the point where you couldn't put the genie back in the bottle, and they had to go through with this whole bloody thing.
Yeah, they had boycotted tea and made coffee the national drink.
Speaking of coffee, I don't wanna shut down the conversation, but if you'd like to have coffee or some cake, please do. I don't wanna take the stuff home with me. Ken doesn't need it.
Well, how about if I take some of it home with me?
Oh, there you go.
And you were also mentioning, amended the Constitution. You know, one of the groups that, Coffee Party USA is affiliated with at the national level is Move to Amend,
Mhm.
and they're actually the group working on, you know, getting a constitutional convention together to actually amend the Constitution to
Well-
reverse Citizens United.
Right, well, I'll tell you something. There's a very interesting point in what you've said, and I wanna see if I get it, because it's wonderful. That's wonderful. It's wonderful to hear that there are some people that are saying, you know what, if this is the way to solve the problem, then we're gonna go to work on getting it solved in this way. But you said a constitutional convention. Of course, it's gonna be very important here to say, what is the mission and scope of that convention? Is it for the purpose of amending the First Amendment to reverse Citizens United? Or are they going to talk about a brand new constitution for the United States of America? I gotta tell you, speaking personally, it's very scary to me to think about the possibility of somebody talking about a brand new constitution for the United States of America. But I wholeheartedly support the idea of whatever amendment to address and reverse Citizens United. You know, when women got the right to vote early in the 20th century, that amendment, that purpose, or when we passed an amendment, the Equal Rights Act, I'm sorry, the Equal Rights Act is statute, it's not a constitutional amendment. It is hard and takes a long time to amend the Constitution, and the process was purposely made that way, although it wasn't necessarily anticipated that soon 300 million people would need to participate. But I get scared if we're gonna talk about an open convention to rewrite our Constitution. I'm all in favor of going right at it for Citizens United, and I could probably give you 6 other things I'd like to change. You know,
Yeah.
there's no right of privacy in the Constitution, and there's a big debate going on about whether there is such a right of privacy somewhere in the Constitution, and what does it mean? Speaking for myself in our new technology society, I think we need an amendment that makes explicit a right of privacy and defines it as what it means and what it doesn't mean. That's something I think is very important that I would love to see. I hope there's 6 conventions on my favorite issues. You know, you hope that there's 6 on your favorite issues.
Yeah.
We probably have some in common. The ones we have in common, let's work together.
There you go.
That, I think, is the beginning and end of this. What you're doing here, and if you can convince one neighbor a year, if you can get one more person in here every 2 months, that's what grassroots really is about. But it's about expanding your numbers and expanding your networks at that level. If you do that, I think you can overcome whatever's happening at the top. But it's hard,
Yes.
because everybody lives in their living room with their eyes on their TV.
Yeah, I wouldn't be in favor of a constitutional convention, because I think the founders are very close to us, actually, in a way, in a lot of ways. You think of it, I mean, some things, like the well-regulated militia bit, I don't know, that's a big problem.
Right,
I think there really is
right.
there's a very big shift in, you know, the potency of weapons.
Mm-hmm.
It takes a long time to load a musket, but if you have an AK-47, you can mow down people without difficulty.
Yeah.
Right.
That's a difference.
And I'd like to say one thing more about this idea of original intent and the founders. Something that's very important to keep in mind if you ever have this discussion. I don't know which way it answers the question, but it's a fact. When the founders agreed on the language in the Constitution, say even in the First Amendment, they all agreed on language, but they didn't all necessarily think it meant the same thing. They didn't agree on what it meant. So to talk about the founders' intent is a fallacy, because even they had different ideas about what it meant. That's the first thing. The second thing that I think is useful and important to remember is they put into the Constitution words like unreasonable searches and seizures, reasonable, unreasonable, due process. What process is due? When they put into the Constitution those words, they did it on purpose to leave it to somebody else to decide at some other time. And I think, and I have to believe, some other time means the decision must be made in the time that the question is asked. So they purposely were ambiguous, and I can't believe that they would be purposely ambiguous and expect you all to be asking what they would have done. That wasn't their point. Their point was, what would you do 200 years from now? So the original intent thing, it's an okay place to start. It's an okay question to ask. But God forbid it's the only question, because none of us really know what they were thinking, and they weren't all thinking the same.
I have a question about some of this. I was given a petition with some signatures for District 55 to bring to our state senator, Dale Ryder, about this. And one of the first questions he said to me was
You said about this, about,
about Citizens United.
okay, good.
And so I did that, and he said, well, this is a federal issue, what do you want me to do about it? What am I supposed to do about it? How do I answer questions like that?
Well, I would think about this for a moment, but the first thing I would say to you is, when the federal government refuses to do something that we'd like to see them do, the state probably has, in most instances, the state does have the ability to do something. Now, a state law could not regulate federal elections, just as I was asked about the federal law not regulating state elections. But if 17 or 28 states started passing laws setting limits on spending in their state, it could set an example and start a trend. And I think that, you know, when you have a number of states doing something, it has an impact both on Congress and the US Supreme Court. So you're right, he can't help us with the corruption in federal government. Can you do anything about corruption in state government? Yes.
What are your thoughts on publicly funded elections?
I would favor publicly funded elections because it is the simplest way to eliminate all of this issue. However, there is a constitutional issue there. It gets on the tougher question I've done so far. Why is contributing money speech?
There you go.
All right? If I can afford to go down to WCIA and buy time to speak to you all over Channel 3 for an hour, and nobody else can, I hope you're not gonna suggest that I can be barred. Because the only reason to bar me from doing that is because either you don't like me, or you don't wanna hear what I have to say. And both of those things, the government's not supposed to do under the First Amendment. So it isn't the giving of money to a candidate, is that speech? I have a problem. I don't know and see how that is speech. I really don't. And I haven't gone back to study what the rationale is that the Supreme Court used when they confronted this issue. It's an intriguing thing that someday I'll have the time to do.
Yes, I thought we were talking about money. How did speech get into this? That was the question.
Yeah, and you know what? I think that that's a really good first question. If I give money to a candidate, why is that speech? Where's the idea in that money?
Yes, how come the money has to go to an ad? How come it can't go to gas for driving around and stumping and all that other stuff? Posters, whatever,
Well,
buttons.
yeah.
Those are all speech too.
Yeah, that's all. Well, we've broadened what speech is, but giving money is a little bit outside even a broad definition of speech, I think, right out of the box.
Yeah, and that philosophically, Ken, is something that someday I'm gonna have to see what possible rationale they gave to that one. I can understand not allowing the government to say, you can't talk, corporation. You can't put an ad out, you can't put a billboard out, you can't put an ad on TV. In First Amendment terms, I can understand that. That's speech. But I don't understand how giving money to somebody is speech.
Yeah. Well, the money is certainly escalated at the very, very top, and that's been noted by
Right,
everybody
right,
with a pen.
right.
But the question is, what do you get to do with the money? I mean, what does that give? What does that really give you if you have unlimited resources?
Yeah, I mean, can the candidate be told? See, that's the problem. The candidate is gonna get the money, and the candidate cannot be told, you can't use that for speech purposes, you can't buy ads. You can't do that.
Mm-hmm.
But to tell the person, well, if you tell the donor, well, whose free speech rights are really involved here? Is it the candidate's free speech rights? Is it the donor's free speech rights?
Yeah. You know what's funny is it's this Citizens United thing. I had no idea it was such an innocuous way in. The idea that it would be some silly movie about Hillary. That is so, and they were so cautious,
Yeah.
being so careful
Right.
not to break the law.
Yeah.
You'd think I had the notion that it was this big wicked corporation that just wanted to be the boss.
It was you may as well think that it was a Karl Rove type of organization who read and understood the restrictions in the law and wondered if by making a DVD and showing it in theaters and selling it or giving it away, they were getting around the law.
Yes, it's very wonky. It's very disingenuous.
And then when they sue for that, to me, the most stunning part of the whole story is they were arguing about Hillary the movie and shouldn't we be able to do this? And you're not going to tell us that law stops us from doing this, are you? And the Supreme Court said, wait a minute.
Somehow knowing full well.
That's a teeny little irrelevant question. We want to talk about the big enchilada here.
Yeah,
That was stunning.
Yeah, because
Right,
usually
yeah.
what you read about or hear about is the court ruled that the issue was only this narrow part.
Right. There's a,
That there-
right.
You know, there's a large issue and the court says our jurisdiction only
Yeah.
addresses.
There used to be a
small,
principle of law that I learned in law school that said, the court will always rule on the narrowest possible grounds and avoid ruling
Mm.
on the
Right.
wider grounds.
Mm.
This court chose to do the opposite in this case.
narrow.
Just like there used to be a principle of law when I was in law school that said that the Supreme Court can say that they're not gonna hear any case that's too political. What? It used to be called the political doctrine. The court didn't want to be political, so the court was not going to hear cases that are too political, because if they're too political, it's Congress's job. You take care of that, too political, or, no matter who it is, we're not gonna do it because we don't wanna look political. The political case doctrine. Now, let's go back to my favorite case in the year 2000, when the Supreme Court picked our president. What happened to the political doctrine that they didn't want it, that they didn't want to look political? Well, since then, it appears that that doctrine has not been mentioned, raised, or it's done. They're perfectly willing to step into the political thicket, and that's what they've been doing ever since. And, you know, as I told you, in my mind, I think it's a very bad, sad thing.
Mark, do you happen to remember who picked the president in 1876? Do you remember the Rutherford B. Hayes?
Well, first of all, I don't think I was there.
No, I know you weren't there. I'm
But
just
yes,
talking history.
yes.
There was a case where it went very much awry, just like it did
Yes, yes.
with, what's his name, Gore
With Gore and
versus
Clinton, yes,
Bush.
yes. And the court in Clinton, in Gore versus Bush, made reference to that as precedent.
They did, but I thought in that case, they picked some committee that did the deed. It wasn't the court that did it.
That is correct.
They picked, the Congress picked a bunch of people. It's, this was it Rutherford
Rutherford B. Hayes.
versus,
I
some
don't
guy
even
named
remember.
Tilden.
Oh, okay, that was in 1876.
1876.
Right.
76.
76.
Right.
Yeah, because that was, basically the trade-off was they would end Reconstruction.
Right,
That was the issue ad.
right. But you know,
But the deal was that they would, the Republican Party at that time was the, shall we say, the Civil Rights Party
Right.
enforcing
The Lincoln,
Reconstruction.
Mhm.
it was Lincoln's party.
Not too far down the road from Lincoln, we're
Yeah,
talking
yeah.
about. 10
And-
years down the road.
And you know, of course, at that point in time, our president wasn't elected directly.
Yeah.
The president was elected only by electors in the Electoral College that were not designated or picked by the public.
Right.
So it was easy for the court to push it back and say the Electoral College and Congress can figure out a way to resolve this.
Mhm.
We're not gonna do it. I mean, can you imagine that we only have had popular election of our presidents in this country for a little over 100 years? For the better part of this country still so far, our president wasn't elected by the people. It was elected by the state houses and the representatives in the state houses. So much has changed. If we think about that 1876 election in the context of today's elections, there's many things that were very different back then.
Yeah, I think in a lot of respects, it's become much more democratized in
Yep.
a lot of ways. And the culture is much more liberal in the sense of progressive now. I mean, compared to when you start reading 19th century American history, it's like, talk about your boondoggles, the Transcontinental Railroad. What a railroad to nowhere. What a bunch of money thrown at something that has largely symbolic, had a largely symbolic impact because of the poor workmanship and graft and just that. But the symbol, sometimes a symbol can take it down the road.
Mhm.
That's what I was thinking might happen with healthcare. I thought, well, now here's a symbolic act because the actual legislation is very weak. But perhaps the idea that it now exists would be like, sticking a finger in the dike, like the transcontinental railroad. was.
Would be would be a step that would
Would be a step
create
that-
some inertia, some
Yeah,
momentum.
there's now we have we've taken a crack at it, and let's fix it. I mean, it remains, it's right in that awkward phase.
Yes, yes.
The only thing that I've been able to contemplate or think about the notion of somehow money being equivalent to speech is whether it's taken as the notion of the quid pro quo, where it's, I'm paying you this money, say something about this, or whether it's being seen as kind of the corporation, for example, if it's, I don't know, Starbucks or something, they're giving money to a certain candidate that's being seen as their stamp of approval or their political opinion of, or.
Well, I think that's right, if I understand what you're saying. The giving of money is communicating that I endorse your ideas, I support your positions, I agree with you. I think that's,
Yes.
yeah.
And that's kind of the only thing that I've been able to contemplate is the notion of why
Me
they're
too.
seeing money as
Me too.
speech.
But I'm going to tell you that I don't like to come up with Mark Ansel on law. I want to, and I'm going to at this point, because you've perked my curiosity, I'm going to go read what the Supreme Court's rationale was and find it. It's there. And I'd like to figure out what it was, because that sometimes gives you either a little bit of vulnerability in the sense that maybe that rationale is so obviously out of place in the 21st century, or maybe that rationale is appealing to me. I need to know their rationale. If it were me, I don't think I'm capable of making those big decisions. I'm only capable of criticizing somebody else making those decisions.
Thank you so much for providing the syllabus. This was really,
Well, he provided it to me, and I
Yeah.
thought, well.
Now, and you should know, the opinion is on the internet. I got that off of the internet, and you could go, if you really are having trouble falling asleep, you can go and read the whole opinion.
What really struck me was and I know it said at the beginning, this is just sort of like a general,
Yep.
explanation. But there's so much in here that is just like blanket statements.
Yep.
And things that go unchallenged, like, they just say, it is irrelevant for First Amendment purposes that corporate funds may have little or no correlation in public support for the corporation's political ideas. Well, who says that that's irrelevant? They're just-
5 justices say that. And my suggestion to you is, if you bother to go to read any more sections, the first place you should go is to read the dissent. They will that will give you, it'll give you the other point of view. Read the dissent.
Yeah, because, and they're making things like, this is no less true because the speech comes from a corporation. Well, who says?
These are supposedly building on a Supreme Court rationale and precedent over the years, but the truth is, if you go back and we want to find things in Supreme Court decisions over the past 100 years to support your position, you can. And if you want to go back over the past 100 years and cherry pick things that have been said in Supreme Court opinions that undermine the
It's like
position,
statistics, you
you
can always
can.
find something to
Correct.
back your point. Yeah, and to add to, and I forgot your name,
Christine,
what
sorry.
you were saying too about,
So that-
there's such a saying, and everybody knows this in the saying, and this is why, to me, money equals speech, as we all know, money talks.
Right.
Money talks.
I mean, if you accept that concept, you've just defined why money is speech. Yeah. That's pretty scary.
There we go.
Yeah, no, and we all know this, and we all know this like for most of us in ways that has been used to silence us. And that, to me, that's the real danger in this. And when let me jump to my other thought too here. So if this is gonna be on the books for a while, then how can we use it to our benefit?
Well, the
And
immediate,
Raise money.
in the short term, if that's gonna be on the books for the next, let's say at least the next 10 years, push for disclosure. Again, I don't know how much of a difference that might make,
Well, that,
But
my,
disclosure is permissible. I mean, I'm sorry, it is congressional laws requiring disclosure are permissible. Let's try and exploit that in the short term, while we try and fight, direct corporate contributions. In the meantime, push for disclosure
but
of
a lot
donors.
of times when I look at like the lists of who contributed to who, I'll see things like, Mothers Against Dying Babies. Well, people name themselves like really
Yeah.
odd things.
Right.
Like Fox News
Right.
bills itself Fox, fair and honest reporting.
Right.
People name themselves what they think that will look. The first time I brought, when I went to go visit Dale Ryder, and then I also went to see Chapin Rose, so I talked with Chapin's secretary. And Senator Ryder's first response was, Citizens United, what's that? And then Chapin Rose's secretary said, Citizens United, what's that? And then she wondered why we could be against it, because something named Citizens United sounded
Yes.
so grassroots. Why would anybody be against
Yes.
something that was the citizens?
Right.
So that's my concern
Right.
about just disclosure, because
Yeah.
people can name themselves.
Well, here's what I'm gonna say to you. I don't know, and I'd like to see the details of the disclosure, whether it actually requires individuals' names. But whatever, I know many businesses, and we see this in the law all the time, you got a corporation hiding behind a corporation, hiding behind a corporation, hiding behind a corporation. Let's start going behind this one. I don't know how many layers we'll have to peel away, but let's get started.
And then my last question was, if they're so about protecting free speech, no matter where it comes from, then why is Bradley Manning still sitting in isolation?
Can I come back next month at 3:00 and we can talk about that? That is a very, very complicated issue.
Well, actually, this is a good point to actually segue to something that he has to hand out about our next meeting, which actually continues this topic.
Okay.
So I didn't want to cut you off.
Okay, no, that's fine, I gotta go, guys.
I know, it's 5:00
Yeah, and we
and,
just thank you so much.
Oh, I
Yes.
do so enjoy, thank you. And I'm so glad that Dale gave me the opportunity, and I do enjoy so much, and I learned from you guys today. I mean, I learned more from you guys today, so it's been a wonderful opportunity for me.
Yeah, and we hope this can be the start of maybe an ongoing relationship. 'Cause,
Well-
I mean, we are looking for prominent members,
I appreciate it, and I understand, the one thing I will say to
he
you.
knows a lot of other lawyers.
I have in my career, in both as a lawyer and as a human being, I have declared myself an independent a long time ago. I have done it for many, many reasons, but for the logical reason of saying that I believe that as soon as I take sides, and I'm not saying I never take sides, but as soon as you take sides, you start losing your true objectivity. You can't help it. And I have worked very hard to maintain as much of my objectivity as I can. Now, I thank you for your invitation, and I'm not saying no to your invitation, but I'm saying that I've worked very hard to maintain independence both in image and in intellect, because I think it helps me in what I do.
Definitely.
But that doesn't mean that I don't vote. And that doesn't mean that I don't support something as one side or the other of an issue. And I appreciate what you guys are doing. I have tremendous admiration, because I don't think there's any other way for us right now to deal with fighting those interests except at the grassroots level. And I also think that the grassroots level is the one possible or potential for the kind of equivalent power.
Yeah.
It's the only way to develop equivalent power. And that the founders absolutely believed and thought and set up for that reason. They anticipated that from time to time, every few decades, that people will rise up in anger and do something about their situation. They gave them the ability to do it without guns. I hope we can do it without guns. Thank you very much.
Thank you.
I'll save you some cake.
Oh, please. Thank you very much. Oh, my pleasure. Thoroughly enjoyed it. Great to see you.
Yeah, good to see you.